the conference has many panels, but I think this is, of course, one of the more interesting ones because we are discovering that this world is global and that even a small French cartoon goes worldwide and has implications on everything, also on our understanding of fundamental rights and freedoms. And it is, I shared, this is not my, okay. So and I think that's why jurisdiction is an issue. And now we can discuss the technicalities of the reform, of the extraterritoriality of laws, and we have lawyers in this excellent panel. But there is also a need to see the wider picture and to ask simple questions about what is jurisdiction and what kind of jurisdiction do we need. So I think these questions are perhaps more useful before we go to the technicalities to reflect about it. And I think this panel composition translate that concern. It is moderated by Cristos Velasco. He's a cyber attorney. I'm going to look at this, but he's sitting there. Cristos, I'm really proud that you do this for me. He's the person that understands internet governance, and he is a manager of the Protección Datos Mexico and the author of a Kluwer book, Cyber Law in Mexico. And I really I'm glad that he's taking the role as a moderator. Left to me is Cornelia Kutterer. I know her she has been a very old friend of mine, one of the first friends of CPDPs and one of the few persons that did them all. And so I'm very proud to present her, not in this role as being there. She has 8 t-shirts of CPDP, but as in her official role as the very important leading woman on digital policy efforts for Europe, Middle East, and Africa of Microsoft. I'm very happy Microsoft is engaged in this debate, so it's more than natural that we asked Cornelia to sit down. And next to her is somebody that's going to be my friend because I'm making use of CPDP of developing relationships with people I admire. It's Dan. He's a professor in Australia and the author of a book, Private International Law and the Internet. As a public lawyer, I'm impressed by that angle. And then next to Dan there is Ana Maria Osula, and she works for an organization. I'm gonna read it aloud. It's the NATO CCD-COA Law and Policy Branch. It's not the NATO. It's not Hert. It's not the military, but it's an institution that stands apart and is devoted to relevant research. And I think that perspective that you will bring in will help us to touch on the broader issues behind jurisdiction. And then on the other side, and I'm so proud of the gender balance and the unbalance, because the women are really leading in this. I'm sorry, Dan, and I'm sorry, Paul, and but it's Julia. She's an internet professor, has been in business when I was still playing cards with my daddy, and she's now Queen's Mary University in the business since 2001, and is the director of thought programs at the Center of Commercial Law Studies. Another interesting angle. So I'm very happy with this panel. I would like to sit there and listen, and I'm going to pass the microphone to Cristos, please.
Thank you very much, Paul. Good morning, everyone. Well, first of all, it's a pleasure to be back here in Brussels. I was here last year, but this year my role would be mostly as a moderator in this interesting panel. First of all, I would like to give a specific background on internet jurisdiction. Internet jurisdiction intersects in different areas of laws, including criminal law and data protection law. And many courts around the world have issued landmark cases on the intersection on jurisdiction and enforcement of national laws, seeking to clarify conflicts of laws in different regions of the world. Among the landmark cases that you might perhaps be aware of are the United States versus Ivanov case. This is in the field of criminal law, which is a very well-known case that deals with internet jurisdiction between Russia and the United States. Then we have, on the other hand, the Yahoo Lycra case, which is also another well-known or landmark case in the field of jurisdiction, and where different areas intersect, like freedom of speech and conflicts of law. And then we have, for instance, in Australia, the Goodnick Downjo's decision, which was a decision that was made by an Australian law, but at the end was settled. But it also raises interesting issues of conflicts of jurisdictions between the United States and Australia. And perhaps for those of you involved in the field of cybercrime, well, you might probably know about the I Love You virus case, which also raised important issues of jurisdictional conflicts, but at the time, the crime of hacking and illegal access was not like criminalized in Philippines. So there were like problems in order to solve or how to prosecute the creators of these viruses. And also another interesting case that also has, was one of the landmark cases in the field of internet jurisdiction was the Frederick Tobin conviction, which was a German national who moved to Australia. And then he created a website with content vilifying the Jewish society. And he was prosecuted in Germany, well, in a city where I currently live, which is called Mannheim. And also it raised interesting issues in Australia. So those are, just to give you an example, some of the implications of the jurisdictional aspects of internet jurisdiction. Since we are in a forum that deals primarily with data protection, well, we know that in the area of data protection, the judgment of the European Court of Justice on the Mario Costeja versus Google case also raises important aspects on the application of the EU data protection framework to search engine indexes that process personal information within the scope of the EU data protection directive, and regardless of the residence or place of business of the data processor. As it has already been mentioned, the purpose of this panel is to show the audience the jurisdictional challenges and problematics presented on the application of national data protection legislation, the disclosure of information by internet service providers to law enforcement authorities under the existing international channels to obtain evidence of possible suspects, and the regional and international dimensions and the scope of national legal judgments by the judiciary in other countries. So in order to sort of illustrate this problematic and these challenges presented with regards to jurisdictional issues, I will first like to invite Julia Hörnle, who's, as it has already mentioned, she's a professor at the Queen Mary's University in England.
Hello, good morning, everyone. I guess my task is a little bit to focus more into the topic of law enforcement and jurisdiction. Cristos has very helpfully, I think, embedded this topic in the wider context of jurisdiction. We're obviously all aware that the internet is cross-border and there are loads of jurisdictional conflicts. And as lawyers, I think we're all aware, really, what jurisdiction means. But I think it's important to make a distinction between different meanings of jurisdiction. I think partly the issue of jurisdiction is so confusing because as lawyers we use the term of jurisdiction in different contexts. So first of all, of course, private international law deals with jurisdiction of the courts in civil matters. That's not what we're concerned about today. That's one aspect. The other aspect, of course, is jurisdiction under international law, under public international law, which deals with the question, when is a state, and in particular its public authorities and the criminal authorities, competent to regulate and enforce a particular matter. And even within the criminal area of jurisdiction, there is the question of enforcement jurisdiction. In other words, when is a police force able to investigate, in other words, find intelligence? When is the police force and the prosecution authorities competent to prosecute, get the evidence, prepare the court case, and then finally, there's the question, when is a criminal court competent to hear a particular case? So all these deal with criminal jurisdiction, but they're actually quite different. And I think because the topic of this panel is law enforcement and jurisdiction, I focus mainly on really the powers of the police and the prosecution authorities either to investigate or to gather intelligence. Now, obviously, in the area of cloud computing and networked computers, the question is, when can an authority gain access to data which is physically stored in another jurisdiction? So, and then there's another complicating factor. The company who controls that data, say it's an internet service provider, if they are headquartered in the same state, but the data is obviously somewhere in the cloud, in another jurisdiction, what is actually the nexus required in order for the police to have, or the prosecution authorities to have jurisdiction? So that, I think, is the topic. So we're dealing here with coercive powers of search and seizure, which requires some form of warrant, and the disclosure of documents, which I guess in the US you would get a subpoena, or in other countries you also need some sort of court order. And there are obviously particular procedural requirements attached to it. Now, obviously, under public international law and also the criminal procedural laws of most states, the most important connecting factor to exercise jurisdiction is territory. So there has to be a particular link to the territory. Now, the problem is that traditionally, where evidence or other intelligence is in another jurisdiction, it's required to go through the traditional procedures, which is either, if there's no treaty in place, letters rogatory, or if there is a treaty, it's mutual legal assistance. Now, what's the problem with that? Well, that's obvious. It takes probably at least 6 months, if not more, to actually go through these procedures, which usually go through the diplomatic channels. So you would go sort of between the state departments of different countries. So in other words, the request will be sitting on a desk for so many weeks, and then it will sit on the next desk for so many weeks. I mean, I'm slightly being cynical now, but that's how it has traditionally worked. So it takes 6 months at least. Now, of course, cybercrime moves much faster than that. I guess if the police arrest someone, they can't let them incarcerated for 6 months until they wait for the results of the mutual legal assistance to come through. That is the issue. So the question is, can a local court in state A order coercive measures against a local service provider or a foreign service provider where the data is stored in another jurisdiction? So that is the question. So for the court, the question is really, where does the data search occur? Does the data search, and I mean literally the search, occur at the place where the data is physically stored, in the data center? Or does it occur at the place where the person has control over that data? And obviously in the area of cloud computing, there might be 2 different jurisdictions. Now, we have had 2, I think, prominent cases in this area, which some of you, I'm sure, are aware of. The most recent one, I believe, was the Microsoft case from last year. So, in warrant to search a certain email account controlled and maintained by Microsoft. This concerned, I think, a drug investigation. Microsoft obviously was reluctant to disclose the data of their customer, which was stored in Ireland, so at a data center in Ireland. The data center itself was operated by a wholly owned subsidiary of Microsoft, and Microsoft had the control or the power or the ability to get the data in the US. But as I say, the data was physically stored in Ireland. Now, that's obviously a common practice, that the data is stored locally to the client, obviously also for practical issues to do with data latency, etc. The US government then applied for a warrant under the Stored Communications Act, which is the specific, obviously, empowering act in the US. Microsoft disclosed the non-content data relating to the email, because that was actually stored in the US, but refused to disclose the content data with the argument that that's an extraterritorial search. And obviously, there's a presumption that laws are not applied to extraterritorial territories unless it's specifically authorized. The court, at first instance, the magistrate made the order on the basis that it was sufficient that Microsoft had control. That was then appealed to the Federal Court of the Southern District of New York, and the Court of Appeal came to the same conclusion. So ultimately, there was an order that the data be disclosed, even though the data was in Ireland. The case, I think, is going to be appealed further, and I suspect it will go all the way to the Supreme Court, so we will obviously have to watch what will happen with that. The other case I want to briefly mention is the Belgian Yahoo case. This concerned a fraud case which was committed through the use of Yahoo email account. It was a very complicated litigation. There were really two questions. The first question was whether Yahoo, as the provider of a web email service, is actually providing electronic communication services. In other words, a service which is defined as the transmission of electronic data through networks. But for our purposes, the more interesting question is whether, under the Belgian criminal code, the public prosecutor had the power to directly order Yahoo to disclose the communications data. So in this case, it wasn't about the content of the email, it was about the subscriber and communications data. The other difference to the Microsoft case was that at the time, Yahoo did not have an office or other presence in Belgium, so it was completely extraterritorial. They directly served the order onto Yahoo in the US. So the court of first instance made the order and actually ordered Yahoo to disclose the subscriber information and imposed a fine of 55,000 euros and a restraint, in other words, 10,000 euros each day for non-compliance. That was then appealed, and that it was actually quite complicated when the two questions went separately to the Court of Appeal and ultimately to the Cour de Cassation. But anyway, on the 4th of September 2012, the Belgian Supreme Court finds that the request sent by the public prosecutors to Yahoo was actually valid. Obviously, that was 5 years later, so I suspect the investigation by then had either stopped or I don't know actually what happened. But at least at a point of law, in 2012, the Supreme Court decided that the order was validly served, extraterritorial, on the company in the US.
Thank you, Julia. This has been a very illustrative, especially with regards to the Belgian Yahoo case. It's important because it's a case that deals with access to data without having to have a formal mutual channel. And this case, well, was litigated, as it was explained by Julia. And it's also an important case to be considered in this pragmatics of internet jurisdiction. Okay, and then I will have Ana Maria. I forgot to mention, I'm allowing the speakers a maximum of 7 to 8 minutes for interventions, and then we will come up with questions, and then I will give room for audience participation. I will try to have at least 10 minutes interaction with the audience. So, Ana Maria, please.
Yeah, thank you. Hello to everyone in the audience. Thank you for the organizers for having me over. Thank you for the chair and for the moderator for putting this great panel together. And thank you for Cristos and Julia for giving a very good introduction to the topic. So I will just build on the things you have just put forward. I will share today bits and pieces of my research on trans-border access and the jurisdiction to enforce. And this is really the results of my own research projects and my own research activities, and does not reflect in any way the official opinion of any other entity or organization. The focus of my research is similar to what Julia very well described. What are the legal limits of the law enforcement entity to access data as part of a cybercrime investigation or any crime investigation that is located abroad in a foreign jurisdiction? It's relatively easy to understand the need for such an access. Think of botnets. The botnet Zeus takeover, game over that was taken down last year by FBI and a number of states and other partners, consisted of more than 1 million computers worldwide. So you can easily imagine why cybercrime investigations entail the need to access data located abroad. So there are a number of options for accessing this data. Julia very well described already MLATs, the agreements between the states. In addition to that, there are additional agreements such as the Council of Europe Convention of Cybercrime that facilitates the exchange of information between the signatories of the convention. Then there's also the possibility, again mentioned by Julia, by accessing the service provider, either in your own country or then trying to contact the service provider abroad. And finally, there are cases of informal cooperation when you contact directly the law enforcement entity in the foreign country in hoping to get quicker access to information like this. This might work in closer countries or in regions where it's easier to have these kinds of contacts, but clearly it doesn't work very well globally. So, according to United Nations statistics that was published in 2013, 70% of the cases of cybercrime investigations where there is the need to access data located extraterritorially actually use MLATs, which is funny given the examples brought by Julia saying that it actually doesn't make sense. If an MLAT takes you up to half a year to get the data, then clearly this does not really fit the time-critical needs of cybercrime investigations. MLATs also have other problems. For example, some of the MLATs might not be really up to date or include the necessary operational means needed for quick exchange of information. Also, you might not have an MLAT with a certain country you need to cooperate with at a given time. Or finally, you might have an MLAT, but the country might just refuse or find a reason why to refuse or to decline your request. So what are the alternatives? There are lots of articles, lot of studies being done about why MLATs are not really the perfect solution. So what else is out there? Of course, one of the clear options to make the situation better is to improve the MLATs themselves, make them more effective, build trust between different states, or in certain regions like the European Union, you can build more closer, more effective frameworks, such as the joint investigative teams option run by Eurojust and Europol in the European Union. But that also doesn't fully cut it, because we know that currently cybercrime investigations are often faced with a problem that is called the loss of location. A situation where, due to the use of cloud computing or due to the use of anonymizing techniques such as the Tor network, it is not fully possible to 100% determine the location of the data. And once you don't know the location of the data, it's very difficult for you to first-hand approach the country or any country. And hence, cooperating or contacting the service provider would really be the first logical choice. But what I am really concerned with in my research is the option known as direct access or transborder access. This is something that we know some states have followed. We know some states are advocating for such possibilities in their national law or have already adopted similar provisions. And this would actually allow the state, under certain conditions, such as loss of location, to directly access the data. There has been a case, there are several cases, but one of the most well-known was from the Netherlands when they were taking down child pornography servers. And there are articles claiming that they directly access this data and these servers. So how does this come into play now with the topic of jurisdiction? Now, jurisdiction to enforce is a term lawyers use to describe one of the functionalities of jurisdiction. It derives from the Lotus principle put forward by the International Court of Justice, and it prohibits the state to exercise in any way its power on the territory of the foreign state. So the question now becomes whether, if you really access data directly on the territory of the other state, whether this would be an example of such an exercise of power. If yes, this would be possibly breaching the sovereignty of the other states and might lead to unnecessary and hopefully undesired escalation of retaliation activities. So therefore, there's a clear need to look more into effective operational tools. And this would be the first conclusions of my intervention. That there's a clear need for more operational tools for accessing data residing in foreign jurisdictions. Of course, the claim as such is not new. It has been out there for years. But we can see little success in trying to come up with solutions that are at the same time operational and then transparent and clear. This is the element that we're often, unfortunately, missing. Secondly, there are options provided by the Council of Europe Convention of Cybercrime and the discussions on the possible additional protocol on transporter access that really do try to address this issue, but currently states have been unable to find a consensus on the exact interpretation of the central terms for the Council of Europe Convention of Cybercrime Article 2032 and also on the additional protocol. Thirdly, the topic of direct access, I think, is becoming more and more topical, and states are dealing with this. I know the Netherlands is proposing a rather concrete amendments for their legal system. So this is something we need to pay attention to. And finally, from the academic perspective and from someone who looks into on how the principles of international law are developing over time, we can see that since the current need for more operational tools is probably not going away, rather it might only increase, then I think what we will see in the future is the development of the traditional principles of jurisdiction rather than staying in the traditional scope of these principles that we have been used to talk about throughout the years. All right, my time is up, so thanks.
Thank you very much, Ana Maria. Well, she made an excellent point with regards to transborder access to data. As part of the reminder, I've been doing some work in the field of cybercrime, and the Budapest Convention had like one provision, Article 32A and the Article 32B, which deals with access to data in third countries. So, as it was already mentioned, this issue has been analyzed under the scope of the TCY Committee of the Council of Europe, and they are still like trying to look for a proposals on how to come to this issue. But on a well, it's also important to mention that this issue of transborder access to data is not new. It's definitely not new. It was raised in 1999 during the former G8 group. There's actually a set of guidelines with regards to transborder access to data, and sort of like that guidelines have been somehow implemented in the Budapest Convention to a certain extent. But when it comes to practice, I mean, the practical focus is also important because, I mean, there's academics, there's a lot of people dealing with this issue, but the ones that really suffer these things are like the digital forensic experts. I mean, I have different conversations with digital forensic experts all over the place, and this is an issue. And also law enforcement authorities, they are claiming that they are not accessing data in third countries without any legal basis, but in fact they are. And there are some really illustrative examples also in Belgium, for example. They have like some provisions on how to access data on third countries. And well, I'm not gonna go into detail with regards to this, but this is just a reminder of how important it is to raise this issue at the international level, not only at the European level, but international level, because accessing data is becoming more prevalent. You know, after the Snowden revelations, yeah, perhaps there's more awareness about like civil society on how important it is for us to protect data. But on the other hand, we have law enforcement we have this anger of law enforcement for getting access to more data to investigate cases related with crime. So, well, as a third speaker, I will have my friend Cornelia Kutterer. We have known. Okay, well, we'll have Dan. Am I a friend as well? Or? Yes, of course. We just actually met in this conference. And I was surprised because, well, he sent a paper and he's been also involved in the field of internet jurisdiction, and, well, he will clarify his paper. But Dan has a very, very interesting background. He's from Sweden, but he's been living in Australia for the last 16 years. So he has an interesting perspective on how these things on jurisdiction would evolve in the next years. So please, Dan, go ahead.
Thank you, and I want to start by congratulating Paul and the other organizers on a truly successful conference. Here you really get extremely immersed in data protection and privacy thinking, to the degree that personally now, when I was sitting here coughing, I didn't think of it as a bodily function, but rather as an involuntary disclosure of personal health data. It's the level of immersement in privacy thinking that you get to here. We're dealing with a topic here that I think has so far largely fallen between different chairs, right? Those active in private international law says, well, data protection is a public law topic, so we don't have to bother about it. Those dealing with public international law don't know that data protection areas exist. And those active in data protection have, and I'm going to offend a lot of people here, but I think so far there's been too little attention given to the international issues. Where attention has been given, it's been largely in the sort of area of cross-border data flow, and not so much these jurisdictional issues that also are very important. But a lot of things are happening now, and I think finally now there seems to be a greater appetite for serious reform. So that's sort of where I would like to build on. Because the principles that so far we work with and that sort of restrict what we're doing, it's very rough, but you know, these 5 principles, or rather 6, perhaps we could say 6 principles of jurisdiction that typically always come up. And we got the duty of non-intervention and the sovereignty concept and the doctrine of comity and so on. These are the sort of things that we always come across when we're talking about jurisdiction. And so far, all the discussion, in my view, too much attention has been given to trying to fit internet jurisdiction issues within this framework. And the reality is, I'm afraid, it just doesn't work. And we'll explore some alternatives here. One problem is, and we can relate this to the Microsoft case that already has been mentioned. If we change the slide, please, Paul. Thanks. So if we apply these principles to the Microsoft case, well, the US might argue that territoriality principle is supporting the US because there's no boots on ground in Ireland. Whatever Microsoft is asked to do, they can carry out from the US, so it's clearly territoriality supports the US. Nationality, well, Microsoft is a US organization and so on. And the EU can argue that there's a violation of sovereignty. The territoriality principle can again come in and support Ireland because the data sits in Ireland. That's the argument we've seen, for example, in Albrecht's amicus. He says because the data sits in Ireland, European law applies and so on. So the reality is that the principles we have can support and also be used to object to pretty much all the approaches that we see being taken in relation to internet jurisdiction. So they're not particularly helpful in providing any guidance. Now, some of you will be confused here and say, well, isn't this case between actually Microsoft and the US, not Ireland and the US? But the reality is, of course, Microsoft here is very much the meat in the sandwich, right? What we're talking about is a conflict between US values and European values to a great extent. So what's the source of all these jurisdictional principles that we seem to be taking for granted? Well, in 1935, there was a research exercise that resulted in something called the Harvard Research Draft on Jurisdiction with Respect to Crime. And that document has then been incorporated into virtually every textbook on public international law and in courts and so on. So we are now stuck with these principles identified 80 years ago, and they are dictating how we think about jurisdiction. And I think that's unhealthy. Because 1935 was very different. If we change slide again, let's think about what else happened in 1935. Well, we had things like the first canned beer was sold. So things have moved on. Abortion was legalized finally, and driving test introduced. Radar was a new and exciting technology. And paperback books were released and so on. And the one I think is most interesting to compare to the Harvard draft is this style of underwear on the picture there was launched in 1935. Now, what do you think of when you look at that pair of underwear? Well, some will say they look cosily supportive. And that would be the same people probably who thinks that the Harvard draft principles on jurisdiction are closely supportive. I look at those underwear and think they are uncomfortably restrictive. And that's exactly the same approach I take to the Harvard draft on jurisdiction. The principles we have in the Harvard draft are uncomfortably restrictive for our modern society. So what can we do to get rid of them? Well, to get rid of these principles, we need to think more about the reality of where they come from. So we can change the slide again. You didn't like that one? All right. Yeah. So there's a few things to note about the Harvard draft. Well, first of all, there's things like it was only meant for penal matters, and it's been given a life way beyond that. And these are just general principles as a restatement of what state practice actually was at the time. And somehow that has been allowed to cement the thinking for the last 80 years, and I think that is highly unfortunate. Some of these principles are then very useful from a perspective that they simplify reality. So instead of looking about real interest in a matter, you can say, does it fall within the territory or doesn't it? Or what's the offending party of a nationality of a particular country and so on. So they're binary, some of these tests, while the reality is much more complex than that. What we need to do is realize that these principles then are just proxy principles for underlying core principles that we should be looking to instead. And this is particularly important when we're dealing with a relatively new area to which we're trying to apply the law, yeah? Instead of looking at these proxy principles and see how they affect what we're doing, we should find out what are the real policy considerations that we're dealing with that underlie the whole thing, and how would they best be balanced for what we want to achieve. So I suggest instead that if we change the slide, thank you. If we distill the essence of the Harvard draft principles that now represent public international law, maybe the two underlined broader principles I state here could be the new way to look at it. So, under international law, jurisdiction may only be exercised where there is a substantial connection between the matter and the state seeking to exercise jurisdiction, and the state seeking to exercise jurisdiction has a legitimate interest in the matter. Those two principles, I think, are what all these other proxy principles are trying to say to a degree. And I'm not trying to change when we let countries exercise jurisdiction so much, but I want to change the way we think about what is the basis for that. As you will note, there's no reference to territoriality here. So the fact that data sits on a server in a particular country, in my view, doesn't mean that it automatically has a substantial connection to that country, and that that country has a legitimate interest in that data. Those are the things we should be focusing on instead. And then I throw in the third one there to also, in a sense, dispose of comity and those sort of things. Now, if I can be allowed another 12 seconds, I wanted to note that, so looking at the Google Spain case, everyone would be aware that Google was asked to remove or de-index certain content, and a reasonable man would assume, I suppose, that that was limited to Europe, or maybe even to Spain. Then the Article 29 group told us that, in fact, to be effective, you need to block or de-index also for .com, because otherwise people will just circumvent it by using the .com domain. Well, if you really want to get this content and you have a IQ sort of above room temperature, you will probably then figure out that you can go to google.com.au or some other country domain, yeah? So blocking on .com will not be enough. So to be effective, you're going to have to end up blocking in the whole world. That might be fine in this particular case, I don't particularly care. But if you set that as a precedent, then what about other countries' laws? Should we allow, if something is illegal, if let's say it's illegal to criticize good old Putin in Russia, should then Google have to de-index anything in the world that is criticizing Putin? That would seem to follow from that type of reasoning, and I think it's very dangerous. I have gone a little bit over time. Thank you.
Thank you, Dan. Well, You made a good illustration with regards to international principles on jurisdiction. These international principles are mostly contained in the great majority of international conventions, UN conventions, also the Council of Europe conventions, and a lot of countries have implemented those principles either in their national law or in the criminal law. Just one question that should be kept in mind is whether those principles should remain, but how could you make those principles to be implemented on a more practical basis, especially considering that cybercrime or criminal law is very territorial. It's very territorial. When you talk to criminal lawyers, they said, well, if the conduct has effect in my country, then I have jurisdiction to enforce. So one issue that I keep struggling about, especially when I provide like training in the field of cybersecurity and cybercrime to law enforcement officials and employees of companies, is that, I mean, they find that this principle still continues to apply. And I mean, when you implement those principles, there's also the issue of sovereignty that has also been raised. And there's also this mentality, especially among judges and prosecutors, that they don't want to change. They don't want to change the principles. So I would like to have your opinion on that, on how those principles could evolve in order to be more effective on a practical basis.
Obviously, territoriality will always keep being important. If someone is speeding on the streets in Australia, of course Australia has a legitimate interest in regulating that, and there's a substantive connection. So we might, in 99% of cases, end up with the same result with the principles I've proposed as we do under the Harvard draft principles. It is in that important other 1% case where the difference lies. For example, the idea that just because data happens to sit in a server in a particular country, as in this now the Ireland case, the idea that gives jurisdiction automatically, that's where we would see the real change. And how we achieve this change, well, as you say, there's a lot of mind change that needs to be achieved, and this is the very, very first step, unless we can here adopt the sort of Russell's research draft convention on jurisdiction or something today.
And also, I don't know if you remember, there were also many, many years ago another principles dealing with jurisdiction, the famous Stanford principles, that sort of like were created parallelly with the cybercrime convention. But those principles never remain valid. They were just like an academic inspiration, but they're still available, and this is also important, for the academic field. Thank you. Well, now I will have Cornelia Kutterer. Cornelia Kutterer works for Microsoft, so she would provide like practical perspectives inside the organization with regards to jurisdictional issues.
Thank you very much. Before it becomes too academic, and I feel very humble on this panel, I thought I'd give economic, a legal, and a political perspective to the issues, and Dan has described us as the meat in the middle of a sandwich. I guess we internally call it the catch-22 situation, that most of the companies around the world in the cloud computing business are currently stuck. So from an economic perspective, I think everybody agrees that cloud is not territorial. In fact, it has its truly economic benefits if it is not territorial. At best, it is regional. Microsoft has cloud computing centers across the world, and we have usually twin data centers for backups in regions, and that means that not all countries in which we operate have a data center. The uptake has certainly had a lot of discussions around trust in the cloud, and not least because of the Snowden effects as well. And we have seen across the globe that countries do react to it to this perceived loss of sovereignty in sort of two ways. Either they try to maintain sovereignty through requirements that require data to be localized, or the other way around is that they maintain or enhance procedural rules that are sort of a long-armed jurisdiction, the extra-jurisdictional reach that has been already discussed, which is subject of the Microsoft case and has been subject of the Belgium Yahoo case as well. And so we are stuck with a sort of understandable sovereignty reaction of national states and the economic cloud paradigm, which brings, in particular as we talk in Europe around the digital single market and the digital economy, so much to the potential achieving the goals that the new Commission is trying to achieve in those next 5 years. And then we have, and the case was already substantially described, Microsoft, in order to overcome that trust issue, we do see that it seems that even within the European Union, users trust more their own country rather than another country. The case in that respect makes a lot of sense, but it's only a case with one judgment eventually. In either way, I think it is useful to have this discussion to find a wider solution that is adequate in a cloud computing environment. Which basically brings me to the legal aspects. So clearly the sovereignty and territoriality is the issue that we are trying to overcome. We have seen, interestingly, within the European Union, starting solutions such as the European Investigation Order, which has not yet been discussed here. But be it EU-US AMLET agreement, the European Investigation Order, or the convention, there is always several issues that remain problematic. So first of all, the court case will not solve the overall issue. We will need to go into those international agreements and see where we can find solutions. The current situation is that most or many countries, even those which have ratified the Cybercrime Convention or exceeded the Cybercrime Convention, do have unilateral production orders that they issue on service providers that have that data stored elsewhere and not in their own territory. The direct data access and the trans-border access that the Cybercrime Convention was over the last 2-3 years busy with trying to amend and interpret newly has gotten stuck because of the resistance both from the members as well as from the privacy community. However, I think it's useful that all that work has been done within the cybercrime community, the Cybercrime Convention community, the Cybercrime Committee, and they have issued a 200-page, really worthwhile read, 200-page report on the existing mechanisms of the AMLETs. And I want to mention at least 2 solutions that would require an amendment to the Cybercrime Convention, but might be a useful starting point, not only in the context of the Cybercrime Convention, but also eventually when the EU-US Mutual Legal Assistance Agreement will be revised. Those 2 solutions would require an amendment to the Cybercrime Convention, but could overcome the difficulties that are perceived by law enforcement with the current MLATs, and I would say the report has many more recommendations adopted. Many of them go towards more procedural improvements of the convention of the current procedures in each country. But the two solutions I think are interesting to explore is an international production order that can be served to the other authority, but which would then just tremendously speed up the way that works, or a production order that is served directly to the service provider, which is having the data stored in another country, another treaty member, obviously, in that case of the Cybercrime Convention. Again, this could be used for other bilateral or multilateral MLAT agreements as well. And both of those solutions would obviously require the necessary safeguards, which we already have in the treaty itself. Now, I want to quickly at least also raise the unfortunate political difficulties in which we operate and try as a company to push forward with solutions. Is within the European Union. I think that came quite clearly, there was a quite clear result yesterday, certainly in the panel with Paul Nemitz and Julie April. There is a lot of the issues we need to sort out before we could think of those solutions. Clearly the umbrella agreement would be, I think, a step forward if both the European Union and the US can finalize that agreement. It requires some efforts of the United States, and I think there is a lot of those processes underway. I'm sure we hear more of that in one of the panels after us. And of course, any of these agreements would require the approval of the European Parliament, and that approval from all the reports that the Parliament has issued over the last year, it is clear they would only agree to that once the data protection regulation is adopted, and potentially the issues around the safe harbor agreement as well. So there are solutions out there which would be more adequate for the cloud paradigm in which we live and have the law enforcement function as they need to, but there is political difficulties in implementing that quite fast. From an economic and from a business perspective, it's absolutely necessary that that the governments, the EU and the US come to those solutions. So that is, we are pleading for adoption of the data protection regulation. Obviously, Microsoft has also supported comprehensive privacy legislation in the United States and did the efforts that are necessary there too. So I stop here.
Thank you, Cornelia, for bringing up these issues that are also very important with regards to the TCOI work on transborder access to data, which I would like to encourage this audience to read those papers that are available in the Council of Europe website, and there are some proposals there. But it's important that when we talk about data, we are based in Europe. And in Europe, there's a huge level of protection of personal data, whether it's for the private sector or whether it's in possession of public entities. So law enforcement authorities and police sector officials have also the obligation to protect that data. And I mean, these obligations are part of the EU treaties, also the Cybercrime Convention also has a provision, Article 15, on safeguards, like countries should implement safeguards and conditions to protect the rights of individuals and third parties, including the right to data protection, to prevent the misuse of measures by law enforcement authorities. And this is also another provision that still requires further analysis and needs the involvement of different stakeholders, not only at the European level, but at the global level, especially that now data protection laws have been created in different countries, particularly, I mean, I come from Mexico, and in Latin America now there's more emergence of data protection, mostly for the private sector, but these issues are also colliding, because data protection is also a matter of law enforcement authorities, and this issue sometimes hasn't been really looked after at the national level. So thank you very much. And I would like to, well, perhaps you might be aware of the joint statement of the European data protection authorities assembled in the Article 29 Working Party. There's a clause number 9 of the declaration that textually reads, as a rule, a public authority in a non-EU country should not have unrestricted direct access to the data of individuals processed under EU jurisdiction, whatever the conditions of this access and the location of the data. Conflicts of jurisdictions shall be resolved only under certain conditions, example, through prior authorization by a public authority in the EU or through a mutual legal assistance treaty, respectively covering access by foreign law enforcement authorities to data transfers from the EU or to data stored in the EU. Foreign requests must not be served directly to companies under EU jurisdiction. So based on this clause declaration of the Article 29 Working Party, I would like to hear the views of this panel. Perhaps, Julia, could you start with your views?
I think I'd like to inject a little bit of realism into the debate. And I think what I'm thinking at the moment is that it's important to make a distinction between intelligence and enforcement. And I suspect, I haven't done any research in this area, but that intelligence, to some extent, always has operated extra legally. So we always had services which were at the border at the edge, I think, of the law. There was always an amount of secretness, I think, about how to gather intelligence. Enforcement is a different matter, I think. But I think there has to be also, I think, an element of realism there, which I think is important in this debate. In relation to how, and then in relation to territory, I think, in a way, the core of the problem, I think, here is the cloud computing paradigm and the territoriality principle. I'm not sure whether we can get rid of the territoriality principle as such, but I think a general principles in the line which Dan has outlined, I think what we also need to think about is about procedural protections for defendants. So it's one matter thinking about competence of states to enforce and investigate, and it's another matter to think about procedural safeguards. And I think in particular, perhaps there should be some rules on the probative value of evidence gathered directly, the fairness, and potential redress. So I think if we keep those aspects in mind, some sort of international agreement perhaps becomes more agreeable, I think, politically to protecting citizens. So I think in some ways the Article 29 Working Party still, to an extent, tries to not fully accept the new cloud computing paradigm, but I think in a way it doesn't help us if we don't do that, because cloud computing is now with us, whether we like it or not. So I think we have to think of a new paradigm, and we have to go back to the underlying principles, such as also protecting the rights of the defendant. So if we can reach some international agreement on how we deal with the evidence which results from such law enforcement action, and how we make sure that that evidence is fair and that we think about its probative value, then I think perhaps the objection to losing the territoriality principle is less strong.
I really like this buzzword paradigm shift, because I mean paradigm shift involves like different scenarios, different things. You know? When you talk about, especially when you're talking about like the cloud, how could you make those changes be reality among, like, you know, law enforcement authorities, the companies involved in the disclosure of information when access to data has been requested from law enforcement. I think it has to do much more with the mentality of the individual to change that paradigm. I mean, cloud computing, as you mentioned, is here to stay, but there are other issues that needs to be changed in the mentality of a number of individuals. Cornelia? Does anybody want to answer? Yeah? Okay, I'm going to open the floor now to participation. Please make sure to give your name, the company or the entity that you represent, and please be very brief with regards to your question. Here, do we?
Douwe Korf, Professor of International Law. I was on an earlier panel where I raised some of these issues. I'd like to mention one thing, and that is the Council of Europe Commissioner for Human Rights in December issued an issue paper on the rule of law on the internet and the digital environment, which I might add I drafted for him. It addresses quite a lot of these issues, but from a human rights perspective rather than from a law enforcement perspective, which I think seems to dominate the debate here. Let's just stop, they're still working. Two things. One, Dan, I really disagree with the way you present these principles. What you were talking about are the principles that dictate when a state is entitled under international law to exercise jurisdiction. But what is important here is the principle when a state is not allowed to exercise jurisdiction. And then you do not have to go back to 1935. I'm quoting from the International Law Commission report on jurisdiction 2006, just one sentence. With regard, the governing principle is a state cannot take measures on the territory of another state by way of enforcement of national laws without consent of the latter. With regard to jurisdiction to enforce, a state may not enforce its criminal law, that is, investigate crimes or arrest suspects in the territory of another state without the consent of that other state. That must remain the overall principle. You will throw international law out of the window if you say states don't need to respect the sovereignty of another state. When you are talking about the difficulties that Western neat, nice law enforcement authorities might have in accessing data in Russia or somewhere else, what about put a mirror in front of yourself? Would we be happy with Iran or China or Russia grabbing data from in Europe? I totally agree with the Article 29 Working Party that that would be outrageous. And on the Cybercrime Convention, particularly Articles 26 and Article 32, and the limitations on the Human Rights Clause, they're heavily criticized in this issue paper with reference to the original drafting by intentions of the drafters. They did not intend to give a carte blanche for data grabs across borders by law enforcement agencies. And my final point, I will never accept that there is any state agency in any state under the rule of law that operates outside a legal framework. The fact that we have seen the spooks, the GCHQ, the NSA, and the other intelligence agencies behaving as if they were not subject to the law is outrageous, and that must change. We must come up with a system under the rule of law for both the intelligence agencies and the law enforcement agencies, which, by the way, are getting increasingly intertwined. We cannot have a situation in which we say it's unrealistic to expect the spies to behave according to the law. No, the opposite. We must make them behave according to the law. Thank you.
Thanks for making those points. Yes, please.
Hello, I'm Felicity Gary. I'm a barrister from London, but I also have a research post at Charles Darwin University in Australia. I spoke yesterday about data and privacy issues in the context of human trafficking, and in fact have been talking quite a lot about extraterritoriality in the context of being able to prosecute people who commit crime in different jurisdictions. So serial rape, human trafficking, you can think of the examples. Taking on board your proposals there, which I have to say look as though they're taken from common law conspiracy principles, to what extent do you think there is a real confusion here between the difference between jurisdiction and evidence collection? Because what we're actually debating today is ways in which to collect evidence that is held on cloud computers. And I have to say, I am a lawyer that is prepared to change from your comment earlier on. I think sometimes the debate gets bogged down in territoriality and sovereignty and doesn't distinguish between prosecution and charges and law enforcement in that context and the collection of evidence. Perhaps what we need to think about is another way of writing the Cybercrime Convention, looking at collection of evidence. Just wondered what your opinion was on that.
Well, you bring an interesting issue, but like it's really, really hard, especially when you're talking about a convention. It takes many, many years to have an instrument in place. So my view is that we should really use what is available and make it happen more on a practical basis when it comes to the implementation at the national level. And and that involves also data collection, data retention issues. I mean, it's just like a whole package that it's not included in, that it's included in different conventions and different frameworks, but it should be seen as a whole package. That's my comment. The gentleman here on the left.
Thank you. I'm Peter Swire. I'm a professor at Georgia Tech, and I'm doing research on MLATs. I have a factual question based on the experience of the panel. Within the last few years, a lot of the webmail services have gone from unencrypted email to encrypted email. And that seems relevant because in an unencrypted world, you can do a wiretap locally. If there's a person in Belgium connecting to their server without encryption, the local Belgian police can do an investigation. If it's encrypted, which all the major webmail services are now, that wiretap is useless. It just gets ones and zeros. And so then the pressure to find the evidence through the cloud provider, who usually is far away, becomes much greater. How much of these factual changes put additional pressure in your experience on these MLATs and other instruments? Because you could imagine an enormous increase in the cross-border flow simply as encryption communications become more prevalent.
Who would like to answer this question?
I think the movement of most of the internet companies is clearly towards encryption. It was certainly a reaction to the understanding that the communication was intercepted, so trying to avoid, enforce authorities to go through the rule of law procedures is a way, or is one of the reasons to encrypt. It's not the only reason. There's obviously other security reasons for that calls out for stronger encryption. Cybercrime attacks obviously are just as crucial to safeguard against. What we see obviously now with the recent tragic attacks in France, and since we're here in Brussels, in Belgium, the situation in Belgium is not necessarily better from a security perspective. We see now clearly, not only in the UK but elsewhere in Europe, more calls that would allow some. It's a beginning discussion, some key guarded for law enforcement. So some of you might have seen the agenda points of the Council of Justice and Home Affairs next week, where this is indeed one of the topics. So we'll have probably to see how this discussion will evolve. Despite that discussion, I think companies will continue to deploy better and more encryption. So that's all I can say at this stage.
Thank you, Cornelia. Dan, perhaps you might want to make another intervention?
Yes, to those two earlier questions to the gentleman at the front, I would say, yes, we have a principle that we can't have law enforcement in another country's territory. The only problem with that is that there is a disagreement as to when that occurs. That's the heart of the whole Microsoft case, isn't it? The US says there is no extraterritoriality because the enforcement sword is going to be carried out by Microsoft in the US. Ireland and others say it is extraterritorial because the data sits here. So it's a wonderful principle, but it's still not functioning in practice, so we wouldn't have that debate. To the lady, my fellow Australian, I have suggested elsewhere that we need to separate out investigative jurisdiction. I would say investigative jurisdiction is not the same as judicial jurisdiction, certainly. Everyone agrees with that. It's not the same as legislative jurisdiction. I say it's normally grouped with enforcement jurisdiction, but I think that is wrong too, because you might very well have an instance where you can have a jurisdiction to investigate something, but you conclude that it's better enforced in a different country. I think we should separate that into a fourth category of jurisdiction. Again, it's something that needs to happen over time and as a concept, but that would be my proposal and something I would be happy to discuss further.
Anna Maria?
And may I just add on the jurisdiction to enforce, which I think is a very, very important topic that I also mentioned in my presentation, deriving from the Lotus principle of ICJ. So it's certainly something we cannot underestimate. But at the same time, that was already also reflected by this panel. Jurisdiction to enforce as a principle of international law, like any other principle of jurisdiction, is not static. So it will be changing with time. And we can see that the Microsoft case is a clear example of these debates raising more and more. So I think with the need for more operational means to fight with cybercrime, these issues will be raising up, but without the evidence of state behavior or the opinion from the states, we cannot really say that we can see the changing of international law yet.
Unfortunately, we have to wrap up. We have to finish up. I would invite this audience to follow the conversation outside this room, or perhaps in the restaurant, well, in here next door. Thank you very much for your attention, and look forward to your input.